Hi, my name is Anja and I teach public law and human rights here at the law school. Since the enactment of same-sex marriage legislation in late 2017, religious freedom claims have frequently been headline issues in the news. You may remember the media controversy around Commonwealth laws that allow religious schools to expel LGBT students, as well as more recent media coverage of Rugby Union Australia's sacking of its star player Israel Folau. These matters have generated a lot of controversy because they involve conflict between religious freedom and rules that prohibit discrimination and harmful speech. In response to this, the federal government has produced legislation known as the Religious Discrimination Bill. And my aim in this short talk is to give you some context in terms of existing rules on non-discrimination, which can then inform your decisions about whether you think all the parts of this draft legislation are useful and necessary. I will also introduce some of the research work I have done applying a human rights framework to these issues. Non-discrimination is central to human rights law. It's found in Articles 2, 4 and 26 of the International Covenant on Civil and Political Rights, and it's closely connected to the foundational human rights principle regarding the inherent dignity and the equal and inalienable rights of all members of the human family. In other words, equality is central to the human rights system. Discrimination on the basis of a person's religion is prohibited under international human rights law, alongside prohibitions of discrimination on a range of other grounds, including race, sex, political opinion, and a number of other attributes. Now, discrimination on the basis of religious belief is prohibited in Tasmania, as well as in most other Australian states. At the Commonwealth level, there are specific statutes prohibiting discrimination on the basis of race, sex, disability and age, but there isn't yet a Commonwealth statute prohibiting discrimination on the basis of religion. Now, the proposed Commonwealth Religious Discrimination Act is intended to fill that gap. And this part of the draft bill is not controversial. It implements one of the recommendations of the 2018 Ruddock Panel Report on Religious Freedom. Other parts of the draft bill, however, deal with slightly different matters, and these are controversial. I'm going to deal with these in a moment. But first of all, what does a religious discrimination law look like? To understand that, it's useful to look at how this is dealt with in the Tasmanian Anti-Discrimination Act 1998. That act prohibits discrimination on the basis of religious belief, affiliation or activity in the context of employment, the provision of education, the delivery of goods, services and accommodation, as well as in membership of clubs and industrial agreements. For example, it would be a breach of Tasmanian law to refuse to employ someone because they're a member of a minority faith. The Tasmanian legislation then provides some exceptions that allow discrimination on the basis of religion in certain defined circumstances. For example, Section 51 provides that if having a certain religion is a genuine occupational requirement of a particular job, then discrimination on the basis of religion is permitted. There's also an exception for the employment of staff and enrolment of students in religious schools. They too may be chosen on the basis of their religion. Furthermore, Section 52 allows discrimination on the basis of religion in the training and appointment of clergy and others participating in religious observances and practices. What you see at work here in the Tasmanian Act is a balancing of the human right to be free from discrimination on the basis of religion against another human right, namely the right of freedom of religion and belief, which includes the right of churches and people of faith to worship, observe, practice and teach their beliefs. Under the Tasmanian Anti-Discrimination Act, the prohibition and the exceptions in relation to religion cover about a page of legislative text. In contrast, if you've looked at the draft Commonwealth Religious Discrimination Bill, as I expect that you have, you will have found it to be a very long and complex document, much longer and more complex than the parts of the Tasmanian Act dealing with discrimination on the basis of religion. The Commonwealth Religious Discrimination Bill is not only long, but it also contains a thicket of cross-referencing between different sections, the exact meaning of which is extremely difficult to work out. I spent months studying the first and then the second draft of the bill, and I found it a bit like an unbelievably complex and unsolvable puzzle. In fact, while this bill has attracted a lot of controversy, the one thing most commentators agree on is that it's unacceptably complex. This impenetrable complexity is a problem because in Australia, the principle of the rule of law requires that laws must be clear and accessible. And in fact, in a decision of the High Court handed down just last week, Justice Edelman reminded us of the importance of that requirement. He said, words of a statute are not a secret code for lawyers. They're enacted to be read and understood by reasonable, informed people using their everyday tools of language. Now, why is the draft Religious Discrimination Bill so much more complex than those parts of the Tasmanian Anti-Discrimination Act, which we just looked at? The answer to that question lies in the fact that the Religious Discrimination Bill seeks to do much more than the Tasmanian Act. In addition to prohibiting discrimination on the basis of religion, the bill seeks to provide broad rights for religious organisations and religious individuals to act in accordance with their beliefs, even where such conduct would otherwise be prohibited. Now, typical points of controversy, as you are no doubt aware, arise in relation to religious beliefs prohibiting sexual relations outside of the heterosexual marriage, beliefs around the unsuitability of women for leadership roles over men, and beliefs in relation to reproductive rights, including access to contraception and abortion. For example, this draft bill would allow employees to express religious views about homosexuality, even where this is contrary to employer codes of conduct that require inclusiveness and respect for diversity. And in this regard, the bill appears to respond directly to the controversy around the sacking of Israel Folau. The bill also incorporates provisions to permit religiously owned organisations and welfare agencies to refuse services in accordance with their beliefs. These provisions appear to respond to a high-profile case where a church-owned but commercially run campsite was held to have breached a Victorian law prohibiting sexual orientation discrimination when the campsite managers refused a booking from a community support group for gay youths. Other parts of the draft bill seem to be directed at giving greater freedom to street preachers. Now, you may have seen news stories about complaints to state discrimination tribunals that street preachers have made comments harmful to members of the LGBT community. In fact, the draft bill directly overrides parts of the Tasmanian Anti-Discrimination Act in regard to public speech. Let me explain how this would work. The current Tasmanian law prohibits public statements that offend, humiliate, intimidate, insult, or ridicule persons with a personal attribute that's protected under the Act, and that includes sexual orientation, gender identity, and disability, and many other attributes. Now, the draft Commonwealth Bill would allow individuals expressing a religious belief to offend, humiliate, intimidate, insult, and ridicule persons in this way. Instead, public expressions of religious belief are prohibited only if they reach the much higher threshold of being malicious or likely to harass, threaten, seriously intimidate, or vilify persons. As a result, there would be a double standard of protection in Tasmania, one for the public expression of non-religious beliefs and another for the expression of religious beliefs. The draft Religious Discrimination Bill also includes a provision to allow doctors, nurses, midwives, pharmacists and psychologists to refuse to provide any health service to which they conscientiously object. For example, this provision would allow pharmacists to refuse to sell contraceptives, psychologists to refuse relationship counselling to gay couples, and doctors and nurses to refuse treatment to transgender patients. These provisions appear to respond to another Victorian case where a doctor was found to have breached a law that requires medical practitioners with a conscientious objection to abortion to refer patients to another doctor who will give advice on that matter. This provision perhaps also responds to overseas cases where courts applying human rights law have held that religious freedom does not entitle pharmacists to refuse to sell contraceptives or relationship counsellors to refuse to treat same-sex couples. Finally, the draft bill also affirms that religious organisations, including schools, hospitals, aged care, welfare organisations and accommodation services, on the basis of their religious beliefs, may refuse to employ or may dismiss employees in ways that would otherwise not be permitted. It is important to note here that this provision in the draft bill is similar to broad exceptions for religious organisations that already exist in Commonwealth Sex Discrimination Act. In my work, I've shown that the provisions I've just outlined, including the exceptions in the current Sex Discrimination Act, are not consistent with international human rights law. And this is so for a number of reasons. I mentioned two of those here. First, human rights law requires the nuanced and context-specific balancing of all relevant rights in a given situation. Now, the provisions in the draft bill that I've outlined provide for rights of people and organisations of religious faith, but fail to adequately accommodate other people's rights to equality, to privacy, to work and to health that may be limited by the exercise of the rights of people of faith. Secondly, the provisions are so broadly worded as to make them capable of arbitrary application. Now, human rights law makes it very clear that arbitrary limitations of rights are unlawful. For example, the draft bill, and here it mirrors the current Sex Discrimination Act, would allow religious organisations to dismiss or refuse to hire someone because of their sexual orientation. So what would a human rights consistent approach look like? Let me give a couple of examples of nuanced and context-specific approaches to the balancing of rights. One example, while it may be a reasonable balance of rights for a chaplain in a religious hospital to be required to be of a particular faith, it may not be a reasonable balance of rights for a cleaner in that hospital who has no contact with patients to be required to be of that faith. And that is because in those circumstances, the cleaner's rights to their religious freedom, as well as rights to privacy and work, outweigh the right of religious groups to maintain their religious institutional autonomy. Similarly, while it may be a reasonable balance of rights for a small, spiritually inspired charity to require all of its employees to actively share that religious faith, that may not be a reasonable balance for the employees of religious schools, hospitals and organisations that offer a wide range of secular services to the public. I'll conclude with one more example. It may be a reasonable balance of rights in some situations for employees of a church to be required to adhere to religious rules on marriage and divorce. For example, there have been several cases by the European Court of Human Rights which held that teachers of Catholicism could be dismissed when they failed to adhere to church rules on divorce and remarriage. In that scenario, the employee was carrying out a task central to the right of freedom of religion, namely the teaching of religion. In another case, the court held that the dismissal of a church organist who breached church rules by divorcing and remarrying was not consistent with a balanced human rights approach, taking into account the very heavy impact of that dismissal on the organist's right to work, as a result of the fact that there were very few job opportunities in the community for organists. While in some specific circumstances, a religious organisation may dismiss an employee on the basis of their religion or failure to adhere to religious rules on marriage, human rights law is very clear that dismissal of an employee on the basis of their sex, sexual orientation or gender identity cannot be justified by a religious employer's right to religious freedom. The right to equality in those circumstances outweighs the right to religious institutional autonomy. Australia, as a party to the International Covenant on Civil and Political Rights, is obliged to protect all the human rights set out in that instrument. A holistic human rights approach, as demonstrated by the European case law, shows how that balancing of conflicting rights can be achieved. And applying such a human rights framework is a way of respecting both the legitimate autonomy of religious institutions and the rights of others to equality, privacy, family life, work, and health. If you want to find out more about the ways in which some provisions of the Commonwealth Religious Discrimination Bill are incompatible with international human rights law, the submission of the Australian Human Rights Commission on the draft bill is a really good place to start. This and hundreds of other submissions on the draft bill, including by religious organisations, can be found on the website of the Commonwealth Attorney-General's Department. I too have made a number of submissions, and I've also published articles on this topic that you might find of interest. In this short talk, I've tried to show that the current Commonwealth Religious Discrimination Bill, if passed into law, will do much more than prohibit religious discrimination. It contains additional provisions that will dilute existing protections in our community against discrimination, harmful speech, and the denial of healthcare. I look forward to answering your questions on the 3rd of September, and I wish you all the best with your studies.